For all your legal matters including immigration, bankruptcy and credit card problems, divorce and family law, landlord and tenant matters, criminal and personal injury, call Gahey & Associates for a free initial personal consultation at 718-263-5999.
जब कोई बात बिगड़ जाए, जब कोई मुश्किल आ जाए, तब हम आपका साथ देंगे. Anytime you have a complex immigration matter, remember, मैं हूं ना. Hello viewers, this is attorney Naresh Gahey, and today we are going to discuss a very important topic in connection with employment-based immigration. Yes, I know that you all are desperately interested in knowing what's going on with the EB2 category, especially if you are from India and China. And at this point of time, before I begin with the headlines for the day, I have my manager Sandeep Nair, who will be joining me with this interactive session on the employment-based second visa category. Welcome, Sandeep.
Thank you, Attorney Gahey.
It's a pleasure having you on the show as always.
It's great to be here.
Now, the sad news is that you've been trying to see that you're retrogressing the employment-based second category. Are you responsible for the retrogression?
No way. That's the government.
All right. Are you sure? So I should take your word on that.
Yes.
So, folks, we're going to talk today about the retrogression in the employment-based second category. At this point of time, the sad news for our viewers is that according to the May 2012 Visa Bulletin, India and China will be retrogressed to August 15th, 2007. And unfortunately, there's some other news that there's a possibility that this category may also become unavailable for some time. So at this time, if you are from India and if you have applied under the employment-based second category, and at this time if your application is pending, I would strongly recommend you to see that, and if your priority date is current, see that you file it before the end of this month, especially because you can still file for your 485 before we get into May, because in May, as you all rightly know, that we are looking at a huge backlog, and India and China are going to be retrogressed to August 15, 2007. So I think that's not the best news which we have for a lot of viewers. So Sandeep and I will be talking about the options which people have, and a little bit we'll be discussing about the employment-based third category, which is moving very slowly at this point of time, but it's moving at a steady pace. So it's important for us to just take one question at a time, and we'd be happy to answer all your questions, especially which we've received from viewers like you regarding the employment-based second category. Sandeep, do you have any questions from our viewers regarding the employment-based second category so far?
I have a lot of questions, Attorney Gahey. What is the EB2 retrogression and how does that impact me?
EB2 retrogression means at this time, for example, when you go to apply for your green card by the filing of the I-140 petition, your priority date will not be current, and which means you're looking at a long wait at this point of time, which means at this time, especially in May, immigration will only be processing cases wherein people have filed the cases where the priority date is August 15th, 2007. So you're looking at a huge backlog under the EB2 category at this point of time.
Why did the government retrogress the EB2 category?
Because of the enormous demand under the EB2 category. And unfortunately, this is something that we'll be discussing a lot on this show, is that immigration follows the per quota country system, which means every country has been given a quota for the EB2 category. For example, India has a certain number of visas allotted under the EB2 category. China has a certain number of visas which have been allotted. So it goes by the quota system. And the quota for India and for China has been exhausted. Now, my recommendation is that if we can do away with the quota system, then I believe that this will be a great relief for a lot of people from India and China. And recently there was also a bill which was proposed by one of, I believe, the congressmen or the senators trying to get away with the per quota system, but nothing has happened so far. So unfortunately, even if you're looking at the EB2 category or the EB3 category, we are looking at some serious backlogs at this particular point of time.
So if I can't file under the EB2 category, what can I do?
If you cannot file under the EB2 category, it's sad because most of these people don't have a lot of options unless and until if you think that you qualify under the EB1 category, which includes a person who's an outstanding researcher or professor having advanced degrees, that's your only option in terms of the employment-based categories. Other than that, if you're single, according to me, even if you can get married to a green card holder, that may be an option for you because even if you're getting married to a green card holder, you can still qualify for a green card in approximately 2 years. So you're not looking at a lot of options at this point of time. But what I would do if I was actually a beneficiary of an application, I would just tell the company to go ahead and file under the EB2 category because EB3 is very much backlogged. So consider the EB2 still as an option. And unfortunately, I must tell you that sometime in October, there is a possibility that EB2 may still become unavailable at that point of time. So I would say that even now, continue to file your applications because it's always going to help you if you file your application. Now, Sandeep, there's one important thing which I must say before I take your next question. Now, the good news is that until the end of the month, if your priority date is current, then you can still file for your 485s. So which means that you're still governed by the priority date, which is actually more towards 2000 to 2009. So if I was in that situation, I would in fact have a very nice talk with my company and tell them to expedite my paperwork. For example, like recently I got approached by someone that he said that my priority date is current and at this point of time I'm panicking very much. I said at least we need to ensure the fact that we put the 485 in because there are a lot of benefits, and we'll be talking about the benefits of having the 485 in at this point of time.
What is the difference between the EB2 and EB3?
EB2 and EB3. EB3, let's start with the EB2 category. EB2 generally applies to people who have an advanced degree or people who have a bachelor's plus 5 years of progressive experience in the profession. Now, very often, based upon all my experience, I've seen people who come in and tell me, Mr. Gehi, I meet the EB2 requirements. Every lawyer who takes on these cases has to be super careful. Couple of reasons is that you may think that you have progressive experience. That's something that is very closely looked on by immigration, number one. You need to have a perfect credential evaluation from a very, very good company because some of the evaluators, are in business, they don't even know what the hell they're doing, and that can have a drastic impact on the employee's case. So the question remains is that anytime you're filing, you've got to be very careful under the EB2 category. Now that's about the EB2. Now what is the EB3 category? EB3 category applies to people with bachelor's degrees and people who are skilled workers. Now that's excellent. So even for example, if you're a cook, not even a chef, and if you have more than 2 years experience as a cook, you can still qualify under the EB3 category. So that is the difference between the EB2 and the EB3. Now, why do people go for EB2 rather than EB3? Excuse me. One of the reasons why people go for the EB2 category is because it is faster. It's faster for you to get the green card under the EB2 category. Plus, you have the qualifications. Plus, the job requires you to have an advanced degree. Now, I'm going to clarify this a little further. I had a guy who came in, he had a PhD degree. And now he said that I'm getting a job in a place wherein I'll be working as a clerk in that particular office. Does he qualify under the EB2? No. Because the position of a clerk does not require a PhD. So remember, most people get confused. It's the job that should require an advanced degree. It's not your qualifications. For example, I have this wonderful degree over here and I'm a certified chef. And, I come from France, comment allez-vous, and you're great. And all of a sudden after that, you go to a restaurant and you're working as a busboy and you want them to spoil you for your H1B, or later on they want you to basically go for an EB2. You're not qualified because what you are doing in that restaurant, irrespective of your wonderful degree as a chef, the hooverer, you're working in that restaurant as a busboy. So two different things altogether. So the moral of the story is that the job should require a bachelor's degree or a master's degree under the EB2 category.
Now, at this point, you said the EB2 was faster, but now because of the retrogression, it's not faster. So
yeah, but it's still better than the EB3, which is far more backlogged. And next time we'll be talking a bit about the EB3 category, including the priority dates, because I don't want to confuse my viewers a whole lot about the EB3 at this time, because today we are going to focus especially on the EB2 category, and later on in our next program, we'll also be talking about the EB3 category in intricate detail so that our viewers can exactly understand what's going on. Now, Sandeep, there's one other thing. I got a call from a researcher, and he was panicking very much. He said, Mr. Gehi, I don't want to get into this EB2 category. So, I mean, when we reviewed his qualifications, we felt that this particular individual does qualify actually under the EB1 category. So, I mean, sometimes when people are brilliant, they don't realize that they actually have the credentials. So therefore, it's a good idea for you to see that you have a fantastic evaluation from any attorney that you're comfortable with. Get a proper evaluation done and try to go under the EB1. And if you have the qualifications, my question is that why not? Even if you get denied, for example, if you're on an H1, you're not going to be very much affected. But if you win, it's like winning the lotto, and you may get a green card. So I feel that EB1 should become a major option for a lot of people. And also, I mean, let me give some tips to our viewers over here. Nowadays, you have online degrees from certified institutions. Just try to see whether you can meet those requirements. And when you're sitting at home on a Sunday, try to take courses if you can. I mean, online, and get your degrees done. And and that's the best way for you to actually consider the EB1 category. And the good news under the EB1 category is that you can also self-sponsor yourself for a green card. So you have to know how to plan yourself in immigration. Now, Sandeep, there's something else which is very important for our viewers, and I thought that we should discuss this issue. And this is about a question that you had asked me, that Mr. Gehi, now some people are about to finish the 6 years on the H1, and if the EB2s are pending, I mean, how will they continue? I mean, that's something that you wanted me to answer. Am
Yes.
I correct on that? So now what should you do if you're in an H1B at this point of time? If you're in an H1, if you filed under the EB2 category or under the EB3 category, at this point of time, even if your priority date is not current, please continue renewing your H1. It's always a good idea for you that even if you have your EAD, let the company continue on the H1, because remember, it's always going to be safe. I mean, that's my policy. And if you are fine and if everything is okay for you, it's just going to work out fantastic for you. Now, people from other countries such as Pakistan and other countries, the good news is that you don't have to worry about the EB2 category. I'm mainly concentrating today as far as the EB2 category is concerned for viewers from India and from China, very much so.
now, let's say my company sponsored me and I was applying for my EB2. I got a priority date, and then I joined a different company. Am I able to port my priority date?
Well, I mean, depends at what stage of the application you are in. And I think like at this point of time, I would say no, because unless and until that's a very specific question, depends on what has happened on the application, whether the perm has been filed, whether, the I-140 has been filed, all those factors are looked into. And at this time, I think porting, you're talking about porting the particular application, and we're going to have a separate topic on which we're going to talk about porting, especially because porting is a very important issue in employment-based immigration. Now, a couple of other things I must tell our viewers is that what happens when companies just jump into filing of EB2s. I mean, when the employee does not have the qualifications, I would request a lot of these companies, not to file, not to even consider the EB2 at that time, because you're looking at an audit. Now, we have many corporate clients, and what I do for them is first I ensure the fact that the particular employee, for example, your company is based in Texas, and and I'm handling all the H1s in my office, and I'm doing the perm labor certifications for you. But I ensure the fact that the employee is safe and the employer is safe, because most companies actually don't take proper precautions when they file documents, and some of them have paralegals who are very knowledgeable, but they don't understand the intricacies of an audit and the consequences upon the company of an audit. Now, recently I had an example of this company wherein they hired someone to do the paperwork in the company. And the person was just filling up the application without knowing the legal ramifications of the application. And that triggered an audit. So the company saved money in the short term, but unfortunately, after the audit was conducted, they wound up paying a lot of money in penalties to immigration. So be very careful when you're a company and if you're filing the perm applications, and you can also be blacklisted by immigration. That is happening a lot these days. And even on H1s, as you all rightly know, there can be audits in your company. And especially if an auditor comes into your doorstep, comes into your company, the first thing is do not talk to him. Retain a very qualified lawyer who knows about audits, especially because you may wind up spending a lot of money in penalties, and I think you should consider avoiding them. Sandeep, I think we've spoken a lot about this issue at this point of time, but I know that you have a lot of questions, and what we're going to do, we'll take a short break, and we'll be back again with some more interesting news from the world of EB2s. Don't go away.
For all your legal matters including immigration, bankruptcy and credit card problems, divorce and family law, landlord and tenant matters, criminal and personal injury, call Gahey and Associates for a free initial personal consultation at 718-263-5999.
जब कोई बात बिगड़ जाए, जब कोई मुश्किल आ जाए, तब हम आपका साथ देंगे. Anytime you have a complex immigration matter, remember, मैं हूं ना. Welcome back, viewers, and we are back with this interesting topic on EB2s. And once again, as you all rightly know, that the EB2 category is going to be retrogressed for India and China, and we are going to look at some more backlog of 2 years and 9 months. So if you are in a situation wherein your priority date is current at this point of time in the month of April, speak to your employer, file your application for adjustment of status as soon as possible before the end of the month. Now, Sandeep, a few things why people should file if the priority date is current at this point of time, why they should be filing before the 30th, for example, before the end of the month. The reason is that once if you file for your 485 application, after that, after 6 months, suppose if your company wants you to leave, so what you can do is that you can transfer to another employer under Section 106 of the American Competitiveness Act, and that's known as under AC 21, you can transfer to another employer. So that is something that I would strongly consider. For example, that right now you're sitting in your company and you know that your priority date is current, but because of some reason, either your boss has been abroad or someone has been not helping you at this point of time, just go to his desk, just beg, do whatever possible and get your application into the door at this point of time, because at least after 6 months you'll have some options. But without doing this, you're looking at a serious handicap in future. If your employer is going to ask you to leave the corporation, then your hope may be to either go back home or again just reinvent the whole damn wheel. So that can be a big issue for the future.
Attorney Gahey, what kind of mistakes can a company do when they file for your application?
When companies generally file for the application, be very careful, because don't misclassify an employee. If you objectively think that this particular employee falls under the EB3 category, go for the EB3 category. And if he falls under EB2, let him go under the EB2 category, because the wages in EB2 generally can be much higher than the wages in EB3. And not many employers understand that, because what happens is that they're still paying them the old salary, and later on when it comes to the I-140 stage, immigration is going to ask them that he's not getting that wage right now. Show me some kind of assurance at least that this particular employee will be getting the prevailing wage which you promised immigration when you filed the labor application for this particular employee. So this is very important, number one. Second, other important thing is that they need to ensure that they advertise the profession properly, because sometimes when you don't advertise properly, and if you have an audit, God help you, because at that point of time you're looking at penalties. There's a very wise saying in Latin which says that ignorantia juris non excusat. which means ignorance of law is not an excuse. So this is what some companies say, is that, well, I was not aware of the consequences. The question is that the auditor will tell you, so you should have relied on legal advice rather than asking your paralegal to do this kind of work in your company. Because even the auditor has told a particular company a while ago that your paralegal did a fantastic mechanical job, but she did not understand the legal ramifications or the implications of of the law when it came to the filing of these applications. And that happens a lot, because every particular block which you're filling on the form has some legal implication. That's why they have it over there.
Is the worst a company can suffer is penalties? Is there anything else that can happen to a company?
Well, people have suffered, depends on the gravity of the crime or the gravity of, of the charge which is brought by the Department of Labor. If they feel that if the company has engaged in serious fraud, you can also go to jail. And that depends, that's a very subjective question, but there can be fines, penalties, and jail too, depending on the nature of the consequences of the particular action. So folks, the most important thing is that see that you have accurate records. And another thing which I've noticed is that sometimes when people leave the company, companies don't even bother complaining to immigration or letting them know that the employee has left the organization or withdrawal. That's another important issue that I would consider. And especially when it comes to H-1Bs, remember, it is your duty to give the employee a one-way ticket back to his home country. And if you do not, you're in violation of the law. You don't have to give a ticket to his spouse and to his children, but of course, you have to give the one-way ticket to the employee. And my policy when I work with a lot of good companies is to ensure the fact that I send the ticket to the employee by certified mail, so that, at least the company is fully protected in the event if there is an audit in these instances.
How often do audits happen?
It can happen at any time. And it can happen when you file one application. It can happen when you file only 7 applications. It can happen when you have around 50 applications or 100 applications. So you have to ensure that this is very important. And another mistake which companies do is that, especially, we deal with a lot of computer consulting companies, but physical therapists also. When they sponsor these applicants, the problem is that they're not working in the area where they're supposed to be working. For example, you filed for the labor in New York, but the employees are actually working in Jersey, and you failed to notify the Department of Labor. You're looking at serious consequences here, because either you misrepresented a material fact or you forgot. And as I said, ignorantia juris non excusat, which means ignorance of law is not an excuse, and you're looking at penalties out here in this instance.
Okay.
So you have to be very careful. And let's sum this up again, especially for some of our viewers who've just tuned in right now. And this is Attorney Gehi, and we were talking about the EB2 category. And as you all rightly know, that we are going to look at a huge retrogression for India and China. So if your priority date is current at this point, please do file your documents before the end of the month, and I'm sure that you're going to benefit a lot. And even I know it's very disappointing. Just be there, do your job. That's all you can do as a human being at this point of time. And in the meanwhile, as I said, again, I'm going to repeat, if your PD is current and the employment-based second category, please file it now, especially because in future, after 6 months, if your 485 is pending under AC21, you will be able to transfer to some other employer.
Thank you, Attorney Gehi, for answering all the questions today.
Thank you, Sandeep. It's a pleasure being on the show, and we have a lot more coming up for you. Keep watching this program, brought to you by Gehi & Associates, attorneys and counselors at law.
For all your legal matters including immigration, bankruptcy and credit card problems, divorce and family law, landlord and tenant matters, criminal and personal injury, call Gahey and Associates for a free initial personal consultation at 718-263-5999.
जब कोई बात बिगड़ जाए, जब कोई मुश्किल आ जाए, तब हम आपका साथ देंगे. Anytime you have a complex immigration matter, remember, मैं हूं ना.